Okay. This meeting of the Temple Bethel Senior Havara is called to order, and we will go straight to our program, which is a talk by Rabbi Suzanne Singer, with whom we are all very, very familiar. I don't think there's really any need to introduce her. So Rabbi, take it away.
Thank you so much, Kevin. So Kevin convinced me to do this session, and it's based on the thesis that I worked on for about a year when I was in seminary. And I've tried to isolate the material that's the most accessible, because nobody wants to hear employer-employee relations in the Talmud and medieval codes. No, that's what my topic was, but I wanted to focus a lot more on the issue of labor and labor unions and that sort of thing, vis-a-vis the Jewish tradition. And, we often say things like, the Talmud says, Judaism says, which, is actually often not actually very accurate, because the Talmud might say one thing, but it also might say the opposite. And things are not as clear-cut as they might be. And my interest in this particular topic was, as you know, I'm very interested in social justice. And so I thought, I wanted to really hone my skills a bit in the area of Talmud. And my professor that worked with me on this, Dr. Stephen Pasamanik, was an expert in the area of medieval codes. So we're not going to go there in any detail. But so it's looking at the tradition of how employees and employers are treated in our Jewish legal system. So I'm going to share the screen with you. What we have to understand, first of all, when we look at the rabbis of our tradition, so we're talking about the rabbis who are, from the Talmud period and later on up until, let's say, the 16th century or so, they're living in a very different milieu than the one that we live in now. So it is very difficult to really look at how they viewed labor compared to how we would look at it in the modern period. So first of all, as you probably know, the rabbis lived in a very tightly knit Jewish community. It was sort of semi-autonomous. They got to regulate what went on within the community. Of course, that does not exist anymore. And they're the ultimate arbiters and enforcers of Jewish law. I mean, rabbi is really a legal term. It's a judge, basically. And of course, a teacher, but a judge probably foremost. And the courts could regulate prices, profits, and competition. So we're not talking about a free market kind of environment. And they enforce the laws through various sanctions. They could attach your property, they could issue monetary fines, even corporal punishment. And the ethical and the economic were not separate. So in today's society, whoever's going to regulate our economy or the laws about employees, they're not going to bring the Bible into it, right? Theoretically, anyway. But in the period of the rabbis, as I said, from the Talmud to the medieval period, that was something that was part of everything they did. The ethical and the moral framework was always operative. So according to Mayor Tamari, who's written extensively about Jewish labor laws, we're talking about a specifically Jewish economic system. And even as Judith Wegner says, she characterized it as a theocratic. One thing that we have to keep in mind is that according to Jewish tradition, working is something that is glorified. It's not like if you have to work, it's a terrible thing. Very different from the ancient Greeks and the Romans, because the ancient Greeks and the Romans thought if you have to work, that's a problem, okay? Not working is the great privilege. It's sort of like people who are really, really rich and have a trust fund or whatever, and they don't actually have to work. Whereas for the Jewish tradition, labor is an ethical commandment, and it's something that's glorified. So there's a very different approach to work than there is in the other cultures of the Mideast. again, what is the kind of environment that we're talking about? So Jewish law rejects the idea that there's a competitive marketplace that will serve as an automatic check against fraud and deceit. So economic self-interest is not going to lead to ethical conduct. And I think we see that in our own capitalistic society, that the marketplace does not end up regulating things in a way that makes it ideal. So you need to have some breaks on how the system functions in order for it to be as fair as possible. Whereas in the Jewish tradition, you have God watching you, right? And so you really have to behave in a more ethical way. And what Judaism does try to do is sanctify the mundane. So everything that you do should have some kind of moral basis. So it's a very different way of looking at things. So in terms of the positivity of how the tradition looks at labor, it considers labor to be the weaker vessel. So as you know, we care for the widow, the orphan, the stranger. So the underdog receives a little bit of a benefit of the doubt, right? And encouragement to redress any kind of imbalance or lack of equality. So there are ways in which Jewish law does favor the laborer, giving the laborer the benefit of the doubt, for example, financially, legally, et cetera. So this is the tradition out of which a lot of our labor organizing has come from when in the earlier part of the 20th century, when Jews were very involved in labor movement in this country, it does come out of this tradition. If you want to set up a contract with a worker, the employer and the employee come together as equals in terms of the contract. Both have to have an obligation to fulfill their end of the contract, and the worker is not supposed to be servile. They're both entitled to retract under certain circumstances. That's what we were talking about before, that, if you want to quit in the middle of the job or you need to lay off somebody, yes, but it cannot be at the expense of the other party. So, for example, if a worker leaves in the middle of a job, and leaving in the middle of the job means that the employer is going to lose money, like they give the example of, taking linen and dyeing it in a vat. And if it sits in the vat too long, it'll get ruined. Well, if you leave in the middle of the job, you're causing the employer a big, financial problem. So in that case, you can't just walk out. But if you can walk out and somebody else can take the job and it's not going to cause financial losses, then that's okay. And vice versa, if the employer says to you, sorry, you're laid off, if the guy can't find another job for the similar price, then the employer has to make up for that. So when we're looking at the framework, the ethical framework, we're talking about laws like you shall not defraud your fellow, you shall not commit robbery, the wages of a laborer shall not remain with you until morning. So this is something that Rusty brought up right before we started. We read about this kind of on Yom Kippur because Isaiah is going to say, you cannot come and pray and fast and do all this stuff if you're going to mistreat your workers. So this is a very important concept, that we pay our workers on time. And then in Deuteronomy, it goes even further and say you're not going to defraud a poor and destitute laborer. We're now concerned about the condition that the laborer is in. And even if it's a stranger, if it's not a Jew, it doesn't matter if it's a Jew or a non-Jew. You have to pay his wages on the same day before the sun sets, because he's poor and urgently depends on it. And otherwise he'll cry to God and will incur guilt. So, we're very much in a period of, concern for the people who are the most vulnerable in our society. And we can't just, let them worry about where they're going to get their next meal. Those two verses from the Torah forbid the employer from withholding wages overnight. And it's so important that the rabbis of the Talmud reverse the burden of proof under contract law, where there's a dispute about the payment of wages. So normally, if someone's accused of owing money, that person can take an oath saying, I don't owe any money. If, however, a worker accuses an employer of owing wages, the worker is entitled to take the oath, and the accused, the employer, must pay. So the employer can't say, no, I don't owe this money. If the worker says you owe the money, the employer has to pay. So that's really, really important. And also, the Bible prohibits a creditor from taking a pledge from a debtor. In other words, let's say, you owe me, $10 and you haven't paid, I can come into your house and take a pledge, like something that's worth $10. But here they're saying workers are granted the right to enter their employer's home and select a pledge that would secure the equivalent of their wages. And the worker is entitled to take an oath, and the accused, the employer, must pay. So even though you're not supposed to go into someone's house and take something as a pledge, the worker can do that. And you have to pay in currency, not in kind. Like, okay, I've got all these beautiful bottles of wine here. Let me give you one instead of paying you. Nope, you got to pay me in the currency. Now, workers are entitled to stop work. So they're not considered slaves. So if a worker says in the middle of a job, I'm done, I don't want to keep going, they have to be paid for the work they've done thus far. Now, the employer is not allowed to break the labor contract. If a worker is laid off while the contract is in effect, and that worker cannot find a similar kind of job that pays a similar wage, they can demand an idle wage, which is sort of like an unemployment, compensation. So this is where we're seeing that the tradition is very much trying to protect the worker, very much trying to make sure the worker is not, overworked, is allowed to stop in the middle of their job, is allowed to be compensated if for some reason they get laid off in the middle of the job, very much protecting the worker. And we're going to see several ways in which the worker is protected. There's a limit on work hours. Because the Sabbath is such a fundamental part of Judaism's architecture, workers must be granted a day of rest, so they don't have to work like slaves 7 days a week. There's also a right to eat. So we're talking about sort of fringe benefits. Workers are entitled to eat as much as they like, provided that the food comes from the field. So we're, of course, talking about agricultural workers, because workers in a factory, they don't know from that. But it was later understood to include workers engaged in the production of food, like in the food industry. But of course, there are going to be limitations. Maimonides, who is a 12th century Spanish rabbi and philosopher, said the worker can't just idle away his time by eating, nor may he eat like a glutton. In other words, he can't just sit there all day and just eat away and say, this is my lunch hour, but it lasts for 5 hours. And also, if, we were supposed to pray 3 times a day. So if, let's say, you have to do the afternoon prayer and it's time for that, there's a shortened version so that you don't take off too much time away from your work. So there are limits to these rights. In terms of health, there's an understanding that if you're going to work, there's going to be some risk, right? You might fall. You might hurt yourself with some instrument or whatever. So the employer doesn't have an automatic obligation to take care of you. But if the injury is caused by defective equipment, then the employer is liable for 5 categories: loss of income, loss of limb, medical expenses, pain incurred, and the shame resulting from the injury. By the way, the eye for an eye that we see in the Torah, that has been understood by the rabbis as not an actual eye for an actual eye, but for compensating in these 5 categories. So we don't pull out someone else's eye if they happen to damage our eye. We have to make up for these 5 categories. But if the employer is not being careful about the equipment, which we see in all sorts of industries today, mining, for example, where there's been horrible mining accidents, or accidents in meat packing plants or whatever, if they are not going to keep their equipment up to par and you get hurt, then you're responsible for that. But sometimes some of the opinions are that even if it's not a liability incurred from a defective piece of equipment, you might still have to pay something if your worker gets hurt. So these are all guarantees to make sure the worker is treated well. Sick and disability pay. So if you fall ill during a contractual period, then you don't have to make up for the time you've lost. And also, if you were injured on the job, there are protections for you. Also, somebody who's older and can't do the job the way he or she used to do it, then you can ask for assistance, and the employer has to bear that extra amount of money. And also, you should be able to find an easier piece of work to do for this person who's older and not make them do what they were doing, all along when they've gotten older now. Local custom is a very important concept in the law for employer employees, because the local custom really dictates how much people get paid and how much of fringe benefits they are entitled to. So it's a floor. It's sort of like minimum wage in our culture. So the floor is how much people get paid and the range of fringe benefits. And then you also can't just go in there and say, well, I'm going to make a different deal with these particular workers. No, if they're paid a certain wage in locale, that is what they have to be paid. If they're used to being fed bread and beans, that's the minimum a worker hired in that locale must be fed. And so obviously food is part of a fringe benefit. And you can't just say, you know what, I'm not going to feed you bread and beans, but I'll pay you a little extra. You can only do that if the worker agrees to that. Now, trade unions and collective bargaining is not something the rabbis ever dealt with, right, until the modern period. Now, the Talmud does recognize the right of worker organizations to regulate wages and to make binding rules and regulations. So, that is permitted. And the right to engage in collective bargaining and to strike is consistent with Jewish religious law. But there is a really strong preference for binding arbitration over strikes. Jewish response are like, if let's say you're in a community that's a smaller community and you're not sure what to do. Okay, these workers want to go on strike. What should I do? The rabbi will write to a rabbi in a larger community that has more sway and say, what should we do in this case? And in most cases, they'll say binding arbitration over strikes. So they don't really like the idea of strikes, but it's not inconsistent with the tradition. Now, I put here employer rights because we have to look at what the rabbis were trying to achieve. As I said earlier, there is a moral imperative to treat workers well and to give them rights. But what is it that the rabbis are trying to accomplish? They are interested primarily in creating an orderly society, thinking that heaven had an orderly society, so we should mirror that here. And they don't like instability, disorder, irregularity, and all of those things. And they don't like change, just like so many of us don't like change. And they say laws governing relations of employer to employee hold that each party must abide by its commitment, and the party which changes the terms of an agreement bears liability. So they're really not favoring one over the other. They do want to protect people who are workers, who are poor, who are needing of their wages, but they also are protecting the employer. And what I noticed in all the laws that I read about is that it's always from the point of view of the employer. The employer shall do X, Y, or Z. So that's an interesting way of, weighing the scales. And so the Israelite economy is supposed to preserve stasis, like the prevailing situation should be always what it is. The rabbis were not revolutionaries. They're working within a specific system, and they do recognize the right to private property. They're not socialists. And it is the property owner who is the only legitimate player in the sense that, again, the laws are coming from the perspective of the property owner. And, all of these other people are all in relation to the householder or to the owner of the property, not the other way around. Now, Maimonides says, even a free man who's Jewish can be used almost like a slave to perform all manner of work, except that which is harmful to his health. So that's a little bit problematic, since we said earlier that workers are not slaves, and that comes from our tradition as well. But this guy thinks people should work really, really hard. Well, guess what? Maimonides worked really, really, really hard. He was the court physician in Egypt. He was the rabbi of his community. So he had to adjudicate all sorts of things during the day and into the evening. He's written about his day, and it is unbelievable how completely jammed up it was. So maybe that's why he thinks workers should work as hard as slaves, but I don't particularly like this statement. One of the law codes, as you may know, the Shulchan Aruch, 16th century, is actually the document that is the definitive law code that is still used today, not for labor matters, because we don't have jurisdiction over that, but for religious matters. And the Tur is an earlier, T-U-R, is an earlier version of that. And so it influences the Shulchan Aruch. So outside of the workplace, there is a limitation on what the employee is allowed to do, because what if you go out all night or you have another job, which a lot of people do these days, and then you go and you want to get a job during the day, you might be like really tired and you might not be able to do such a great job. And also, if you're going to fast and mortify your flesh, you're going to be weak. And how are you going to do a decent job? So they're not allowed to do any of those things. Now, of course, the employer is not allowed to steal the wages of his employees. But so the worker at the same time is not allowed to idle away his time, like by eating a lot or by praying too long or by sunning himself or whatever he chooses to do. So back to the payment of the hired worker. Yes, you're supposed to pay the worker on time. However, there are exceptions, of course. Well, if the employer has the money in hand, then he has to pay on time. But if he doesn't have the money in hand, then he doesn't. And you can imagine an employer who might have cash flow problems, and therefore he can't pay the worker when he's supposed to. Then I don't know what happens. And then a lot of times the employer is going to send out an agent to hire workers. And if the payment has been delayed, any further delay you're not held responsible for it if neither the employer nor the agent delays payment. That's pretty shocking. But as a rule, people were paid on time. That's apparently the bottom line. Again, workers are allowed to interrupt their work to recite the Shema and the Tefillah, which is, what you recite in the morning and in the evening. So in the morning, you start work at 6 a.m. or whatever, time to stop for a minute to do our prayers. But let's say a worker is on the top of a tree, trimming a tree or gathering fruit. He does not have to come down to do the tefillah, only for the Shema. So he's not going to waste too much time with the tefillah, right? Because of the fact that coming up and down is going to take a lot of time. So in the afternoon prayer, there's no Shema. So there's only the tefillah. So at that point, the worker has to stay up in the tree. The blessing after meals. So the worker must not say any benediction before meals and only a shortened version of the grace after meals. And it's called the workman's grace. So for those of you who've been around when we've had a dinner or a luncheon where we've done the Birkat Hamazon after the meal, the one that we do as the reform movement is actually a shortened version of the full one. So, it takes a few minutes to say it, too much time away from the work. So you get a shortened one to do instead. Because the worker's time is not his own, it belongs to the employer. Again, you don't want to waste the employer's time. So again, there's this balancing act that they're doing. So the Torah stands neither for capitalistic extremism with the stress that it has on the employer making a profit, neither for socialist extremism with single-minded emphasis on workers' advantages. So they're trying to find a satisfactory harvest for both, a beautiful little metaphor, but really trying to balance the concerns for both. So now there are a lot of examples. See, Jewish law is really very much about using very concrete examples for things. So it's a lot of times about how an agent goes and hires some workers. So the agent goes and hires workers for 3 dinarim. The dinar was the currency of the day. Now, maybe the employer wanted to actually pay 4 dinarim. He says to the agent, listen, I have enough money, I can pay them 4. But the agent only offers 3. If the workers agree to it, they lose out on getting that extra dinar because they could have said no. They heard 3, they accepted 3, that's what they get. Now, if the agent offers the workers 4 and the employer only wanted to pay them 3, then the workers will be paid 4 if their work is worth 4, or if that's the going rate in time. That's in town. Remember, there's the locale of the environment, which dictates what the bottom line is. So if, let's say, the worker says, okay, I'll take 4, but their work is not equivalent to $4, let's say, then they only get 3. So there are different circumstances and different ways in which they figure out who gets paid what and who gets to lose out on something. So if the employer in the second case wanted to pay only $3 for the work, and the workers do such a great job that it's really worth $4, he has to pay it, even though his agent screwed it up and offered more than he was willing to pay. And again, if the worker quits in the middle of a job, if there's no irretrievable loss, as I said, if the linen is being dyed and it's not stuck in the vat, for 3 days and ruined, then he can quit in the middle of the job. So the worker has to have the freedom of saying, take this job and do what with it. The assumption is that the employer can find someone else. There are lots of people looking for work. But again, if there's irretrievable loss and they ruined your linen, you can go and take the worker's tools and then sell them so that you can hire other people at a higher wage if you need to. Although you do need to try to find someone who's going to work for the same wage, but you can actually hire somebody for higher wages using the worker's tools because they kind of messed up your day. Now, there's one more thing that the rabbis offer as a remedy. So if, let's say, you can't get a legal remedy, like, okay, the employer said they'd pay me a certain amount of money. They didn't, they owe me the money. Okay, we have a redress that can happen where, you've made a sworn statement, you get paid. But let's say it's not about something that can be legally adjudicated. They add a new category that only exists for our tradition and only during this period of time, certainly not today. So they have the moral right to be angry and resentful. It's called teromet. So let's say an agent hires workers for 3 dinars and the employer said you could hire the guys for more money. And if the workers end up only getting paid 3 because their work is only worth 3, they're entitled to be annoyed and resentful. So I don't know how much good that does, but at least gives them permission to be annoyed and angry. So ultimately, I guess the question is the Jewish system capitalism or socialism? And Meir Tamari, back to him, says, neither theory is in keeping with Jewish sources because halacha, Jewish law, imposes important restraints on the free market model. We don't just say, go out there and good luck to everybody. And those who think that it's consonant with socialism ignore the fact that Judaism is really, recognizes the legitimacy of private property and the profit motive and the market mechanism. And there doesn't seem to be any trace of a Marxist labor theory of value in the Jewish concept of wages. And so, even though the labor movement had a lot of Jews involved, you can always pick and choose what part of the tradition you want to emphasize. So here is a big difference with how we do things today. So fringe benefits. In many modern economies, the employer is responsible for providing the employee with healthcare, unemployment, and retirement benefits. However, because the Jewish community is very different from the capitalist one or the socialist one, a lot of these obligations are transferred to society. So it's not always the employer who has to pay for all this other stuff. It has to be the responsibility of the society as well, of the community as well. So we don't lay all that stuff on the employer. And I want to see if there are some questions. We have just a few minutes, I think, for questions. I'm assuming, I don't know, Kevin, did you have a different impression of what the tradition would say about labor laws?
Well, no, it's just that Jewish labor law has continued to develop over the last couple of centuries with industrialization, with a lot of changes in the legal framework for the larger society, and rabbis have. There's been quite a few rabbis have played a role in spelling out desirable ways that Jews should interact with the larger society and act as employers or as employees. That's where it gets really interesting to me. But it's really good to have this background, which is the background that the later rabbinic interpreters have had to depend on. One example of one of these interpretations comes from, I think, about 1830, from, if I'm not mistaken, a big town in Belarus today, and the rabbi was Rabbi Solomon Kluger, who was he was a traditionalist. He was basically a follower of the Vilna Gaon. And his ruling in this particular case, which was a general ruling that applied to everybody in the fair-sized area where he was the head rabbi, was that the rich must pay for the funerals of the poor because they so often heavily influenced the fact that the workers had early funerals due to working conditions.
I'm not surprised.
So, and that was enforced. That was enforced for some years in the area where he was the head rabbi.
Yeah, the problem is that, the Jewish community doesn't, and the only place we have any jurisdiction is in religious life at this point, right? Now that we're no longer, in our own communities in the ghetto or whatever. So, rabbis can say, hey, I think this or that, but doesn't mean anyone's going to necessarily listen to them. But yeah.
Well, the rabbis sometimes have an influence with voters, and voters sometimes have an influence with legislators.
True.
And that can make a difference. In fact, I seem to recall fairly recently a rabbi I'm looking at right now attempting to exercise some influence with legislators.
Yes, and I continue to do that. And, I try anyway.
And also, as you were pointing out almost an hour ago, there have been a lot of Jewish activists in labor unions, and labor unions never existed before about a century and a half to 2 centuries ago. But there were guilds and other organizations that affected how work was organized.
Right.
But,
And a lot of Jews couldn't join those guilds, right?
right. But labor unions have had a big effect, and a lot of Jews have had a big effect on labor unions.
Oh, absolutely.
And they've often been inspired, at least by what they know about Jewish traditions in
Right.
regard to labor, mostly along the lines of defending the rights of workers.
Absolutely.
Because the overwhelming tendency when the employer is the sole authority is to decrease wages, decrease working conditions, increase the production, and therefore make bigger profits for the employer.
Absolutely. Absolutely. Okay, so there is a question. Harvey asked what, and I see your hand, Mark, and I'll go to you next. What did that mean about not doing business with a neighbor's cow? See, again, the whole tradition and the language itself, which Rusty would know pretty well, I think, Hebrew, it's very concrete. Okay, so you don't say someone's stubborn, you say they have a stiff neck. Okay, you don't say someone has, is warm and compassionate. You say they have a soft heart, or, it's always very concrete. And again, all the legal material is, there aren't big concepts. It's all like, so-and-so offered such and such to the laborer, 3 dinars or 4 dinars or whatever. And you have to extract the principle out of there. They don't actually usually cite the principle. So it's always concrete examples. So doing business with a neighbor's cow means unjust enrichment. So, you don't take your neighbor's cow and get milk or whatever it is you get from the cow and keep the money for yourself. Or if somebody entrusts you with their cow, you have to give it back, and you can't just, benefit from it. So it's unjust enrichment. And I believe it was on the part of the employer, but I cannot remember right now. I have to go back to that slide, but that's what that means. I know it's like, what the heck does that mean? Mark, please go ahead.
Being from Chicago, or being who I am, I think of Alinsky and I think of Gompers. Samuel Gompers seems to either compartmentalize his Jewishness or his descent, being a descendant of an immigrant, or doesn't admit to it at all. With the case of Alinsky, he might be walking in the faith, but he is not necessarily what I would say proselytizing or making it well known. Maybe that was a byproduct of the times, because you had the Union of American Hebrew Congregations, Young Men's Hebrew Association. But it's interesting where, as Kevin said, some of the union leaders might just by rote or intrinsically feel the need to advocate for people. There were also some other leaders where you look at yourself and were like, that's not how I was raised.
Well, don't forget, a lot of these people were socialists, and they're the people also who founded Israel, and socialists were very non-religious. So that could be a reason that they, did. And okay, Kevin has an answer. Okay, Kevin.
I'm saying some socialists were non-religious. If you look in socialist newspaper, you'll have to look in socialist Yiddish language newspapers from the early 20th century. You'll see that there's very frequent comments from rabbis, quotations of rabbis, articles by rabbis. Now, it's not all rabbis, it's just some rabbis, but they were pretty important. Yeah.
Okay. And it could also be, as you said, Mark, the time, you didn't really want to necessarily be identified as a Jew. But, certainly, look, did Karl Marx or Sigmund Freud identify as Jews? But they certainly knew the tradition, and they were influenced by the tradition, right? Okay, I think it's probably time for me to stop, because I know you have a business meeting to tend to. So I'm going to thank those who came for this somewhat esoteric presentation and turn it over to Rusty.